It's not gonna be ex parte, okay?
So
Done?
as a result, Your Honor, if there's no ex parte communication, then I'm withdrawing my objection.
Okay,
I just want to make that clear to the court.
that's fine.
The court doesn't.
No, that's fine. You're doing your job. No, you're doing, no, Mr. App, I wouldn't say that. Okay.
I'm withdrawing objection only with respect to this particular meeting.
Okay.
I reserve it with respect to any other ex
All
parte
right.
communication.
No problem. Okay, can we bring Mr. Copeland back in, please? Can we hold off until Mr. Copeland comes back in? Okay. Yes.
Yes, Your Honor. Just to put to the court on the record, it's my understanding from last week's proceedings that Mr. Copeland was actually represented by Mr. Jonathan Melnick, and that the court required Mr. Melnick to be here on Monday. And Mr. Melnick indicated that he had non-refundable airline tickets and that he would have someone appear in his place. So I believe Mr. Melnick is still this gentleman's attorney.
We don't know that. We really don't know. I don't even know if he's entered an appearance for the purposes of this, the circumstances thereof, but I'm dealing with it from the standpoint of Mr. Copeland is on the stand. He's a witness. He's had counsel. He's going to continue to have counsel. So that's the reason I'm stating it is at this point in time. Okay, sir? But thank you for putting that on the record, okay? All right, so Ms. Bumpus, file your motion. But until such time, you're going to need to remain as long as Mr. Copeland is a witness. And once we've had an opportunity to hear that, then I'll go ahead and do that. But it's not timely to begin with because he's on the stand, he's testifying. Okay, so whatever arrangement you had with Mr. Melnick, I'm sorry that that's put you cross purposes with not being able to be released. I don't know what difficulties it causes you otherwise, but I apologize on behalf of the court, on behalf of that. But
Your Honor, we did want to, the state wanted to put something on the record as well, that Mr. Copeland has satisfied at this point his contempt by testifying. So if he remains and testifies, then unless he wanted to, there would be no purpose for an attorney. So long as he remains and he testifies, that's the only if he pleads the fifth or fails to testify will he be subject to being placed in custody. So at this time, he has purged his or satisfied his contempt because he is testifying. So long as he remains in this posture, then we believe the contempt will be completed and he would not need an attorney. So, but I can't.
Well, but that's his choice. That's what the rule gives him 10 days to do. We're kind of saying, well, make that choice right now. We're telling him here in open court to do that. So that's what the court's concern is at this point in time.
But Your Honor, I was representing him for the civil contempt, not as a witness. So that once he purged himself, I should have been released.
Have a seat, madam. I'll call you back on this meeting, okay?
I'm sorry, Judge.
Then you can have a seat. I'll call you back on this. All right, Ms. Bumpus. At this, go ahead, ma'am. You can take the podium, please. At this point, the court is still of the opinion that you need to file a motion to withdraw and give your client an opportunity to respond to that. So once you do that and he has the opportunity to respond to it, I'll calendar it, in fact, for unless he decides immediately that he wishes to not hold your or require your services, but usually he gets 10 days. So,
And how would the court know if he's deciding immediately? Because
well, usually he's hearing, I mean, you know, we have either the time passes and there's no objection that's filed and you get it immediately with, it's granted, or I set it for a hearing and he says, yes, I either don't want you as attorney or I want to have you as attorney. I'm going to get new counsel or I've gotten new counsel.
and so Jonathan Melnick is just able to be released.
See, I don't know what the arrangement was between you and Mr. Melnick. I have no idea. That's not my purview. All I know is that Mr. Melnick was here on Friday. He said he was going on a vacation. I don't know if he even properly entered an appearance in this case. I know that his leave wasn't appropriate in this case because he asserted himself as and represented to all concerned that he was in fact Mr. Copeland's attorney. So, and then Mr. Melnick said that he would have counsel for Mr. Copeland on Monday, and that was you. And then you appeared on Monday. So I do think that you do need to properly withdraw and give your client an opportunity to have the full range of options. So until that's done, now Mr. Melnick may come back and may decide, well, yeah, I'm going to pick up, and I still represent Mr. Copeland, but I need to. I'll take up that issue when it was presented before me. Okay. All right. I'm going to set that, madam, for the morning of the 25th of June at 9 a.m. All right. Let's summon our jury, please.
Judge, may I speak?
Hold on, Sergeant Ingram. Did you want your, your lawyer's not in here?
She not my lawyer.
Well, but you still have the opportunity to decide that, okay? All right. Your client wanted to say something and he said, you're not my lawyer. But as I told him, I was about to tell him that he has the right to decide that issue. And he has to be given due process to decide that issue. So that's why I want that done in this case, okay?
Okay, Judge.
Okay, all right. So at this point, anything else? As in respect to Ms. Bumpus?
You didn't give me time to say that.
Okay, I'm sorry. What else did you want to say?
Mr. Milnick told me that she was only gonna be here for 1 day. And that she was gonna make sure that after she's done then, it was gonna be.
See, but I have no knowledge of those discussions. And because they asserted themselves as your lawyer, you have certain constitutional protections as being represented by an attorney. I don't know what was said to you. I don't want to know what was said to you, but I'm just looking at who showed up and what they told us, meaning that me and the other parties here. So I don't know, and that's my kind of pause in this particular circumstance is that, and I need to find that out. So filing a withdrawal would help the court in this particular circumstance. Yes, Mr. App.
Just briefly, Your Honor, my obligation is always to help, educate, and inform the court. Uniform Superior Court rule does indicate that the 10-day requirement is waived if the client consents to attorney withdrawal.
I tell you what, Mr. Copeland, I'm going to send our jury to lunch. I'm going to let you talk with Ms. Bumpus afterwards, okay?
All right.
And then during the lunchtime hour, and then you can, hold on, wait a second. And then after that time, I'll go ahead and make a decision at that point, okay?
Yes, sir.
All right, okay. All right, is that sufficient, madam?
Yes, Judge.
Okay.
Thank you.
All right. All right, summon our jurors, please.
Do I leave out?
No, sir. Not yet. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Ladies and gentlemen, jury, we've had to work some issues out, as I mentioned, that happens from time to time. And given the fact that it is into the lunchtime hour, I just brought you out to just formally recess you for lunch, okay? So we're gonna go ahead and be in recess until 1:55 and thereabouts, and then we'll come back out at that point in time and see where the afternoon leads us, okay? All right, okay. All rise. All right, ladies and gentlemen, our jury has left us. We'll be in recess until 1:55, and then we'll, Ms. Plumpus, if you'll be back for that point in time, we can go ahead and take up that at that time, okay? We're in recess.